Thank you for tuning into Quimbee CLE. I'm honored to be joined today by Larry Coonan. Larry is a litigation partner in the Atlanta office of Mooring, Manning, and Martin, and he serves as the chair of the firm's technology and intellectual property litigation practice. I'm excited to be talking with Larry today about current issues in technology law. Larry, thanks so much for joining me.
It's my pleasure to join you.
So Larry, you're a litigator. Let's start by putting you out of business and talk about how people can avoid issues in technology contracts before they even get to you.
Sure. And I'd like to say, as an introduction to it, unfortunately, with the way our industry works, contracts get drafted by either corporate lawyers, in-house lawyers, even sometimes litigators. And the people who draft the contracts don't see how they play out if you end up in litigation. And so through years of litigating contracts, there are certain things that I've noticed that are common in contracts. And I got to say, the vast majority of contracts I read are actually pretty good contracts. But every now and then I come across something that I think I wish somebody had thought of before they drafted the contract. And frequently we see people and clients, especially technology clients, who use form contracts for their customer suppliers. And the reality is a form contract may not be good because there could be differences in law, regulation, position of the parties, what's the subject of the contract. And so the things we're going to talk about today may be something that's familiar to our listeners, but it also may be some practical pointers to think about.
Great. Well, let's dive right into it. I think we want to start with common contractual relationships.
Sure. So, contracts, when you're representing an entity, could be with a customer. That customer could be, a hard good in the area of technology. It usually involves either licensing a software. It could involve development of software. There are questions in development we'll get up to a little bit later that have to do with ownership. It could be modification of software. It could be custom modifications that other customers can't use. You've got strategic partners, which would be distributors, joint venturers, outside contractors who may do computer programming for you. Could be your suppliers, which could include entities such as Microsoft, Oracle, that are licensing software to you to then further implement your products. And then your employees, and there are very varied employee issues that arise. Things like non-competes, other covenants, we're not going to cover in this particular seminar. But employee contracts are important with regard to locking down the confidentiality and ownership in work product that specifically includes the development of software. And so there should be a raised bar and attention to those particular confidentiality issues with employees.
Should people be thinking about all these relationships as something completely different, or are there similarities that you'll have with all these relationships?
There are certainly similarities, but where they can be different is, again, a supplier of computer printing paper and your copiers is not going to have the same sensitivity as somebody who might be developing software for you or software for them. When I am asked to review a contract, or if I'm given an introduction to it before I understand the contract, the first thing I want to know is, okay, whose side are we on? Are we the licensor side or the licensee side? Because how we draft a contract is going to be different, or at least the computer software related language is going to be different depending on whether we're the licensee or the licensor. So for example, if I'm somebody who is hiring somebody to develop contract software for me, it's going to be important that I try to get ownership of that software. And there is a whole scheme of rules and regulations under the Copyright Act as to how that occurs. If I'm the licensor, I may try to avoid that issue, and I may want to keep ownership of that software, but license it to the customer. So then I can then further exploit the software for other customers or ventures I may get involved in.